Welcome to Financial Poise Presents, a production of Financial Poise webinars, in which we take a deep dive into a specific topic by interviewing a single trusted advisor or expert on that topic.
My name is Carrie Miller, and I'm the managing editor of Financial Poise. With us today is Jules Martin Haas. Jules Haas is an experienced trust and estates attorney with vast experience in helping clients with their estate planning and helping their heirs and beneficiaries upon his clients' passing. And he's here to tell you, New Yorkers and everyone, why you should have a will.
We've had some preliminary considerations here, a lot of information to start to think about. And, you may be saying to yourself, as a lot of clients and folks do, well, I can put my assets in, an trust for account or a joint account. I don't have like $1 gazillion, so I don't really have to worry about taxes. Why do I need a will? Why don't I just do that? And I'm sort of done in the story. I don't have to pay fees. I don't have to worry about, for provisions and things like that. Well, it's not as simple as that in all cases. If a person dies without a will, their estate is going to be distributed to their next of kin. It's an intestate estate. And what that means is that the state laws, right, here in New York and in every other state, is going to decide who gets their assets. And if you take a look now, we have slide number 3. It lists, briefly in New York, who those people are. And basically in New York, like most places, is a list of priority. And you start with a spouse, you start with children, it goes down to parents, siblings, and so on. It can go down to cousins, more remote relatives. But the fact of the matter is that these are not necessarily the individuals that you want to inherit your estate. And if you have assets that are held, let's say, as joint tenants or with rights of survivorship or in trust for accounts, and that secondary person is not alive and you do not have a will, your estate is going to be distributed according to the laws of intestacy. And that might not reflect your intentions whatsoever. Also, if you have assets and for some reason they are not put into some sort of automatic or what we call operation of law type of account, then again, you don't have a will, you're stuck with the intestacy. And just one quick example, I've seen situations where people have their money, let's say in a trust for account or beneficiary account with a certain institution, and then the institution, for whatever reason, it goes out of business. Usually it's transferred to another institution. They're saying we're closing XYZ Bank and we're being taken over by, ABC Bank. I've seen situations where the new institution says, well, you need to sign all new papers, okay? And unfortunately, they send you papers that don't have that in trust for other information. And the person doesn't realize that they haven't signed up for it, or they don't prepare those documents correctly, and their plan is not going to work. So you really should have a will to back up all of those things that you intended to do. Okay. So what other problems arise? So if you don't have a will, you'll see here that there are some other considerations aside from it going to people that you don't necessarily want it to go to. Okay. It's a lack of control over dispositions. And that really means that it may end up going to people, but maybe not in the way that you want it to. You may have a group of people that are your brothers and sisters, but you don't want to treat them all equally. You may want one brother to get a little bit more, a sister to get a little less, or whoever it is in the context of your disposition plan as far as dealing with your assets. So when you lose control over your assets, it's not really the best way to plan your estate, okay? And that also goes to naming fiduciaries, which we'll talk about in a minute or two in another context. But when you're, just dealing with fiduciaries, you can name your fiduciary, or you can name your executor, whereas your administrator is going to be selected by the law. It will be the same people that you have under the law that are going to inherit your estate. So if you see item B here on this slide under some considerations, it talks about kinship issues. Well, again, this is also a big problem because in order to inherit, people have to prove that they are the next of kin of the decedent. And that's not always easy to do, particularly if their lineage is remote. So to prove that you're a cousin or more remote descendant of this person can be very difficult. And, it takes a lot of time and effort to try to prove kinship. Not only do you have to prove that you're related to a person, but you have to sort of prove the negative. You have to prove that there are no other people that are either equal to you that deserve to inherit, or that there are no other people that have priority of you that would inherit instead of you. And it's not always easy to prove this. You have to show death records and birth records and disprove all of the other people to show that your lineage is the one that deserves to receive assets. I had a case, and it was a probate case with a kinship issue recently. And we had to do a kinship search, which took almost a year to do. And the family originally came from Ireland. And after the research was done, the report that we submitted to court was 250 pages long, and there was like 100 exhibits. So if you have a wide-ranging family, particularly a family that's overseas, it may be difficult to locate people. Records may be destroyed, particularly if the family dates back many years through, through the Holocaust or through various wars and countries that have changed names and administrations over time. This can be a really big problem. So it's always best to do the will to try to lay out, even to whoever you're talking to, and let them know what the kinship issue is. Particularly if there is a kinship issue, you can try to avoid that by doing a different type of plan, either a living trust or something along those lines. You also see an item here that we list as administration litigation. And what that means is, in its simple terms, is this. If you don't have a will, not only does the law decide who is going to inherit your estate, those same people have a right to act as administrator of the estate. So let's take a simple example to sort of see what we mean. Let's say a parent dies, parent has 7 children. Well, no spouse. 7 children have a right to inherit the estate. Now, of course, all 7 children want to be the administrator of the estate. Of course, they want to be in control and charge, and that's what their parents would want, so they say. But the court's not going to appoint 7 people as administrators of one estate. The court might appoint 1, 2. I've seen them do 3. So what you end up having is that, particularly where they can't get along, you have all of these people fighting against each other in court. Different factions lining up with each other, 3 brothers here, 4 sisters there. This one's good, this one's bad, and then the court ultimately has to make a decision as to who's going to be appointed. And sometimes the court will appoint an administrator from the group, but sometimes the court may say, the heck with all of you, I'm going to appoint the public administrator, which is the public official, to deal with this because you guys don't get along and I can't deal with this, and nobody can administer this estate fairly. And in fact, if there are only remote relatives, such as cousins, the court's going to appoint the public administrator. So if you write a will, you're able to select. Let's say you want to treat all of the kids equally or whoever it is, but you say, well, this one person is the best person. You can write your will and say, I nominate so-and-so as the executor of my estate. And 9 out of 10 times, the court's going to honor that nomination. And you can select also an alternate executor, a successor executor. This avoids all of those issues, avoids those problems, and avoids the delay in administering the estate while all of those issues are being fought out in front of the surrogate's court. That's not what you want to do. You also see an item here that we list as a surety bond. Now, what a surety bond is, it's basically a bond that's issued by a surety company. It's like an insurance policy, and it's issued to an administrator or an executor of an estate, and it's meant to act as an insurance policy to prevent the fiduciary, the executor or administrator, from running away with all of the estate assets. And it protects the interests of the beneficiaries, creditors of the estate, people that are interested in the estate. In most administration cases where you have an intestate estate, courts want a bond to be posted. Most of the time when you have an executor, you don't have to post a bond, and the will say that we waive the requirement of a bond. Problem here is that most surety companies are sticklers, and they want you to have good credit. So you may have a very trustworthy person who could qualify as the administrator of the estate, but they can't get bonded because their credit is not good, because the sureties will do a credit check on them. And their credit may be poor for reasons that are really not having anything bad to do with them. So for instance, let's say they went through a divorce and that adversely affected their credit, or they have a big student loan, or someone tried to interfere with their credit card accounts and stole their credit card numbers and things like that. They don't have good credit. They may not be able to qualify for a bond. They can't act as the administrator. So again, these are things that are very important to consider. So when you say, do I need a will? There are many overriding reasons, even if you decide to set up in trust for other accounts, to still do a will to back that up. And one does not exclude the other. You can have some stuff that go on that is transferred under your will, some items that are transferred automatically to people. But you really need to look at it and decide what's best for you, and not ignore the fact that a will can serve a purpose, even if you're going to use pre-designated types of assets.
Just a quick question. You mentioned, all these fights and probates. Can I avoid probate by doing a living trust, or is there, a way to avoid probate?
Okay. So when a person dies with a will, their will be probated, which means that it will be filed with the court, and basically the court has to review the will and other documents and validate the will and the provisions in the will. In most instances, it's a fairly straightforward procedure. You don't have a will contest, you have a spouse, you have children, whatever. You can avoid probate in certain ways, certainly by in trust for accounts or joint accounts or things that go outside of a will. You don't need to probate the will because nothing's passing under it. You can also take all of your assets and put them into what you refer to as a living trust, a grantor trust, or a revocable trust, same type of thing. And in that case, the trust, to effectuate its provisions when someone dies, does not have to be filed with the probate court. It's self-effectuating. And the trustee, whoever the trustee is, the successor trustee, can then just follow the provisions of the trust. There are various reasons to use a trust. It may help in a kinship situation if you're not sure who kinship might be and you want to avoid probate. If you think that a will might be contested, you don't want to have to put the will out there and invite people to come in to contest it. But in most situations, probating will is not going to involve all of those things. But the living will avoid probate. In order for the living will to be effective, you need to go ahead and transfer all of your assets into the living will. And therefore, you don't need to probate, even though you will do what we call a pour-over will, sort of a backup in case you miss something. The fact is that you need to retitle everything. So if you have a house, you have to change the title into the living trust. If you have a bank account, if you have a brokerage account, it all has to be in there for this to be effective. Many people, particularly if it's sort of a straightforward type of thing, don't want to go through the hassle of retitling all of their assets into the name of a living trust. There's more expense, of course, up front to create two documents instead of one document. But again, you're doing what's best for you. So while it's a consideration, if it's the thing that's best, then obviously you would do it. So, there are various things to consider, and it's certainly something within the realm of your estate plan that you need to think about and discuss.
Thank you for attending this edition of Financial Poise Presents. Financial Poise has one mission: to provide reliable, plain English business, financial, and legal education to individual investors and private business owners.